In Ohio, the Lutz case has just been certified to the Supreme Court. I talked to Kevin here, and that's so far they're in their briefing schedule, so there's been no opinion on that yet. But the question is very simple: does Ohio follow at the well, or does it follow the marketable product rule? So West Virginia, the superminority of one, came out with the Taney opinion in 2006. And I know that because when I went to work for InGas, our leases, we had two different leases. We had the pre-2007 leases and the post-2007 leases. The pre-2000 leases said at the well. The post-2007 leases put an entire explanation of what post-production costs were. So interestingly enough, the Baker case, which I'll talk about here in a second, actually had the same group of landowners with one pre-2007 lease and one post-2007 lease. So that somehow that never made it up to the Supreme Court or the Court of Appeals. Not sure if that would even make a difference. I think it would, because you could generally say that the landowners were definitely aware that there was a change with respect to the law. So the cases in Kentucky that we look at and want to focus on are Poplar Creek, Appalachian Land, Baker. All three of those cases, same plaintiffs' lawyers. And then, of course, the Asher case, which is a little bit different case, but there was an issue in there that comes up as far as post-production costs are concerned. And you'll notice that I didn't list taxes as a post-production cost, and there's a reason for that. In the Poplar Creek case, that was the first Taney copycat in Kentucky. They took that to the federal court, Eastern District of Kentucky. And that issue was the gathering, the treatment, and the transportation compression costs, but not severance taxes. That was not part of the case. It got appealed to the Sixth Circuit Court of Appeals. Sixth Circuit Court of Appeals affirmed the trial court's opinion, which, by the way, I believe was a decision on the a judgment based on the pleadings. So for those of you that are lawyers in here, that's not even going as far as summary judgment. That's just saying, based on the paperwork you filed, I will tell you that Kentucky is at the well. So it went up there, and they said, well, if we apply Kentucky law to it, the Sixth Circuit agreed that it would follow the at the well. So shortly after that, the plaintiffs' attorneys doing their forum shopping said, well, we didn't win in federal court, what else can we do? Well, let's take it down to Harlan County. Those rubes down there won't know any difference. Fortunately, the folks in Harlan County are a lot smarter than the plaintiffs' attorneys thought they were. But the bottom line on that was that Harlan County, the Harlan Circuit Court, came up with the same decision. 86 years of Kentucky law following at the well. 86 years. That's how much they would have to pervert that to change it to marketable product. So we won a summary judgment there, or actually a motion to dismiss at the trial court level, and they appealed it to the Kentucky Court of Appeals. Now in this Kentucky Court of Appeals, Kevin, we got a 3-0 in our favor. And they agreed. And they looked at the Poplar Creek case as well up in the Sixth Circuit, and they looked at the 86 years of law in Kentucky and said, we're not going to change that. And incredibly, these 86 years of case law were right on point with the at the well rule. They were right on point. They weren't like this or that, going all the way back to like the early 1900s. So we got an unpublished opinion at the Court of Appeals, 3-0, game over as far as we were concerned. Don't have to worry about case closed. We just got to go resolve those other two issues. Not so. Motion for discretionary review granted. Supreme Court wanted to take a look at that. And I think some of it had to do with this next case. And we did argue it before the Supreme Court on February the 6th of this year. It was interestingly enough a 6-judge panel. The one justice came off the came off the court so that he could run unsuccessfully for governor, which I think was also the one justice that was instrumental in granting the discretionary review. So that hopefully worked in our favor, but we'll see. We're expecting a decision any day now. So going back, I'm going to skip ahead one just to distinguish this. Appalachian land case, it was a sister case to Poplar Creek, went up to the Sixth Circuit at roughly the same time, was decided together, was also ruled in favor of the defendants, or the, in this case, ruled in favor of EQT. And that the Kentucky followed the at the well. But the distinction is that the issue of severance taxes came into this. And in the opinion, they addressed severance taxes as being a post-production cost. Now remember, Poplar Creek, no severance taxes, it wasn't an issue. Baker, no severance taxes, no issue. But in the Appalachian land case, the severance tax issue came up. The certification that came from the Sixth Circuit Court of Appeals to the Kentucky Supreme Court came down about the same week that the Baker case went up to the Supreme Court. And we believe that that might be why they granted discretionary review on the Baker case, because they also wanted to resolve this question of law, whether or not severance taxes are a post-production cost. And just to make the long story short, they then put our two cases side by side when we went up to the Supreme Court. We were at 9 o'clock, the Appalachian land case was at 10 o'clock. So we knew that they were looking at this and looking at post-production costs and severance taxes. And unfortunately, the argument was never made, at least I never heard the argument made, that, well, of course they're not a severance tax or a post-production cost. They're a tax. They're a tax. But that was never before the court. So going back to the Asher case, the Asher case went through the Bell Circuit Court case on other issues, but the deductibility of post-production costs came up in that case, and whether or not severance taxes were post-production costs as well. Before that case came out of the Bell Circuit decided that post-production costs, Kentucky follows at the well, but they didn't resolve the severance tax issue. So that severance tax issue is now in the Kentucky Court of Appeals. So you've got a state court severance tax question going up to the Kentucky Court of Appeals, and then a question before the Kentucky Supreme Court as far as severance taxes, whether they're post-production costs or not. So that's why all four of these cases are relevant. Just a little bit on the way forward. How do we go from here? Well, first of all, I strongly recommend that your leases look something like the lease that when I showed up at InGas in 2008, their 2007 lease spelled out specifically what post-production costs were. And I think I have Jim Kaiser and Karen and a few others in the room here, I think, were instrumental in drafting that lease before I was a gleam in Bill Barr's eyes. So, but that's what I recommend, that you stay away from at the well language and actually spell out exactly what it is you're taking out and why. Have your landmen explain why. Have your leases be transparent and unambiguous. And I think the National Association of Royalty Owners, who actually filed an amicus brief in our Baker case, would even agree with us, and they were on the opposite side on the Baker case. But the transparency seems to work a lot better, just explaining it up front and having good landowner relations as well. And then also, you know, you can negotiate other parts of the lease. Maybe a higher royalty, which might not get out of the room alive with some of these operators in here by mentioning that, but just other bargaining chips out there, or simple things like building the roads and doing things for the landowner. These are the type of simple things that just keep you on the right side of litigation. And then stay current on the developments following these 4 cases, following cases in other states, and strongly recommend the use of counsel in drafting these leases, especially as we get into deeper, more complex wells, because one size is not going to fit all here soon. And I'll save my questions for later. I'll be followed by Karen.
Well, I particularly want to thank Astrid for getting us CLE credit for this, so she ensured that some people came. I'm going to talk about some lease issues. And when you think about, I think about leases, I think about Forrest Gump. Leases are like a box of chocolates. Some pass it back. You never know what you're going to get. You never know how it's going to end up. And this is all I think for. Pass it back. So, not yet?
Karen, are you following my last rule of being the, getting counsel to help you with the...
Yeah. You'll find my card inside each of those wrappers. Are we having trouble getting up there? Okay, well, everybody's got leases. Everybody has, you've got old leases, you've got newer leases, you've got leases. Every time you get ready to make a lease, you figure out something that should be fixed. And every time okay, here we go. We've got caramels, creams, and nutty centers, and I'm not attributing any of those to anybody. But every time we get a new play, here's what happens. We get a leasing frenzy, and we've seen this in Lawrence County, we've seen it in Ohio, in the Utica, we saw it in Pennsylvania. So everybody's out there, the county clerk's offices are full of landmen, you can't get to a book to save you, and everybody's looking for acreage to lease. And they're looking for old leases that, or for acreage that never had a lease on it, which good luck with that. They're looking for leases or acreage that has old leases on it that might be terminated because they haven't been produced. And once the bonuses start rolling in, you've got landowners who are looking for ways to get out of their leases and get new, bigger bonuses because they want in on the new play too. So no matter what your situation is, when we get into one of these leasing frenzies, your leases are vulnerable to both examination to see if there are any chinks and to being attacked and subjected to an attempt to terminate them. Okay, so oil and gas leases terminate 4 ways. You can terminate them by agreement, which we're not considering here. They can terminate according to their terms, and that just means that there's a provision in there that when the circumstances occur, the lease, in accordance with its terms, ends. It can terminate for breach of an implied covenant, and we'll talk about what those are, and it can be abandoned. And you probably don't think about it, but you can abandon a lease, technically and legally, even though you really wanted to keep it. So it's not like I'm keeping this lease. No, you can accidentally, let's say, abandon a lease. And that's one of the things that the folks who are wanting your lease or wanting your acreage will be looking for. So we'll talk about according to its terms. We know that in order to keep your lease hold your lease by production in the secondary term, you have to have production. No matter what your lease says in Kentucky, the courts will interpret that as being production in paying quantities. And that means production at a reasonable profit. And that's even if you're paying the lessor a royalty, still the lease is subject to, or at least theoretically subject to attack if you're not making enough money to create a reasonable profit. And we have seen this argument made in a few occasions by lessors who say, well, you know, you're only paying me like 30 cents a month. You're operating this well at a loss. Your costs, your revenues aren't covering your costs. That's not paying quantities, and therefore my lease is terminated, even though there's production, even though there's royalties being paid. The argument has been made that still is not sufficient to keep the lease in effect. So if we're going to talk about what are paying quantities, we have to think about what goes into that. And is it just the costs of your monthly operation, your lease operating costs? Does it include the costs of your drilling, your post-production costs, your transportation? None of these issues have ever really come to a head, as far as I know, in Kentucky, so we don't have any really good answers for that. But I think it's something that people need to be aware of, because if we do get into a leasing frenzy, we may see this argument come back around. And of course, if you are operating the lease at a loss, so that you're subject to the concept that it's you're not paying quantities, if your lease provides for shut-in, then you can always shut in and trigger, and that would get you out of that. You could always trigger your shut-ins, pay your shut-in payments, and that would get you out of the possibility of being in the paying quantities problem. There are also jurisdictions, in Kentucky we have some cases that indicate that whether the quantities are paying may be left to some degree to the lessee's subjective discretion. We like that as lessees. We might want to make sure our leases actually say that. Let's see, I'm having a little trouble here. Now, we were just talking about the deduction of post-production costs. If you deduct post-production costs in calculating your royalties, and that those deductions make you either operating at a loss or operating at a marginal revenue status, you may have even a greater risk of having it argued that you're not producing paying quantities, and therefore that requirement that keeps your lease going in the secondary term has not been met. So yes, you benefit economically if you arrange your lease so that you deduct these third-party costs, but you need to realize you may have a little bit more risk of this paying quantities issue. So how can you fix this? Well, if you're doing a new lease, you've got the opportunity to deal with it. You can say, if we have any production at all, regardless of the amount, regardless of the revenue it produces, that holds us in the secondary term. That would be great. You could define paying quantities and say exactly what it is, and that as long as the revenues from the well exceed the direct monthly well operating costs, it's paying quantities. You could expand that to say that that we won't take temporary market conditions into consideration. Or you can say anything that makes me unable to have paying quantities that's outside my control excuses it, and then you would have another defense. Or you could, as I said, just contractualize this subjective standard that says, yeah, we have to have production, we have to have it in paying quantities, but it's in paying quantities if we say it is. And that gets you out of this whole problem. Okay, so another way that the lease can terminate is according to its terms. And we know that in the condition, the continuation of production is a condition to keep the lease going in the secondary term. Now, that said, because your well stops for a minute or a day or a month, doesn't mean that necessarily your lease is terminated. okay? There's a gray area here on what's called a temporary termination of production, which is typically more tied to circumstances like freeze-off or equipment failures or equipment you don't have parts or something like that. So the courts will look at how long the production was stopped for and why the production was stopped in determining whether that cessation of production caused the lease to terminate. And of course, if you have a shut-in provision, which of course you should if you're doing a new lease, and most older leases to some extent have them, then you could save your lease that way. One thing that is very helpful to have in your shut-in provision, and of course across the board, is this notice and cure provision, so that if you forget that your time to pay your shut-in payments came, the lessor has to tell you, hey, you didn't make your shut-in payment, then you get to make that up and you don't accidentally have a clerical lease loss. Because again, when people are out there looking, poking holes, trying to find a way to get your acreage, then things that never mattered before will suddenly become important. The fact that your shut-in payment was a day late will suddenly become important. And if nothing else, that's a reason to re-examine your clerical procedures to make sure that if you don't have the luxury of writing a new lease, you at least make sure that you have compliance with your old ones. You can be terminated for a breach of a lease obligation, but that's only if the lease has a termination and forfeiture provision. The maxim is the law abhors a forfeiture, and a breach of a lease provision typically does not provide the basis for termination. I can't tell you how many lawsuits I've seen where people say, you didn't pay me the right royalties, therefore I'm terminating the lease. Well, if the lease doesn't say that you can terminate it, you can't. So when you get that lawsuit, just say, call your lawyer and say, no, this can't happen. Now, it will happen, and you'll probably get a judgment against you in circuit court, but eventually it'll work its way out. But the failure to pay royalties or the failure to pay the right royalties creates a contract claim, not a reason for terminating the lease. Now, if your lease does have a forfeiture provision, you're in a whole different world. Implied covenants. Whether you intended for it to be in there or not, there are 6, in some jurisdictions count them differently, but generally 6 implied covenants in every lease. They're implied because the law says they're there, whether you use those words or not. And the covenants get put in there unless you say there are no implied covenants, or you have an express term that would address the issue that the implied covenant would address. So you can prevent it from being applied by having an express term that prevents it, that is, it addresses the same thing. So what are those? Excuse me, 6 implied covenants. Initial exploration. This is to get the lessee on there and working. This doesn't apply so much in these days where most leases are paid up and you have a disclaimer of any requirement that you get immediate production. Protecting from drainage, with our spacing rules, we don't see that quite so much. It's really hard to prove drainage, and so that one, kind of thinking you probably aren't going to have too much problem with. Here are the ones that come up when there's a new play. Reasonable development. If you have a lease and you have, say you have a 500-acre lease and you drill one well on it in one side of the property, that well is held by production, or that well holds that lease by production. But if there is an implied covenant of reasonable development because you didn't block it out, then you have an obligation to develop those other acres. And if you don't develop those other acres and the lessor follows the procedure, your lease can be terminated, at least as to those additional acres. And so this is one of the big ones that people look at. So if you haven't gotten, if you didn't fully develop the property, then you're subject to one of these, a claim of a breach of an implied covenant. Now, just because they say you should have doesn't mean that you've breached the covenant. That these are totally factual situations, and so that the lessor would have to prove that a reasonably prudent operator, that's the standard, a reasonably prudent operator would have drilled this additional acreage, and there would be a likelihood of producing additional economic production. So, further exploration, thank you. Sorry. Further exploration is another one that comes up when we get new formations, because then the lessor is saying, well, everybody else around me has a Rogersville well. Lessee, you need to drill me a Rogersville well. Well, if the facts bear that out, it may be a breach of an implied covenant to not drill a Rogersville well. And so the question is, again, would those other formations or those other areas of the property, would a reasonably prudent operator drill them? And it doesn't matter whether you have the money or not, okay? This is the hypothetical reasonable operator who, can do everything, has everything they need. It's a standard that's not tied to you. If they would do that, then you may have an obligation to do that. Market production, we talked a lot about. Harry talked about that. And then sort of a general overarching obligation of reasonable care and due diligence. So that one, if you're really a bad operator, maybe, but these two, the further exploration and the reasonable development ones, are the ones that come up when we get a new play that people are trying to get rid of old leases and get new acreage. So how do you avoid that? If you're having the luxury of drafting a new lease, say there are no implied covenants. Just say it. Just say it. That everything, that the obligations of the lessee in this lease are in lieu of all implied covenants. Then you're home free. If you either can't get that or you don't want to go whole hog, you can take these specific things like the obligation to drill additional areas or other seams, and you can say, I don't have to do that. And when you say, I don't have to do that, and you get a contractual agreement, that prevents the implied covenant from being inserted into your lease. But if you do that, you have to be careful not to put it back in, because there's a provision I see in lots and lots of leases that's actually a kind of a force majeure provision that says, all of the express and implied covenants in this lease are subject to all state and federal regulations. Do you hear what you just said? You just said there are implied covenants in this lease. So if you have paragraph 28 down here that says there are no implied covenants, and paragraph 20 said all the implied covenants are subject to federal regulation, you just ran the risk of putting implied covenants back in your lease, even though you tried not to. So you have to be consistent all the way through. I'm going to talk about one other thing really quickly, because I know that, you do have one safety valve, okay? Because in order to enforce an implied covenant, the lessor has to give you notice and make a demand for performance. And that's a point at which you can say, no, really, there are no Rogersville shale wells in this county, and a reasonably prudent operator wouldn't do that. And then they can sue you or not sue you, but they have to give you notice first. Let's see here. One other thing really quickly. The other thing that happens, we'll skip over abandonment, except to say that if the circumstances would indicate that you weren't intending to produce that well, like you haven't done anything on it for a long time, or you took all the equipment off of it and moved it to the neighboring property, the court can easily say you abandoned it even though you intended to keep it. So just thinking that you wanted it doesn't save it. Top leasing is what happens when people come in and they put another lease on top of yours. And it doesn't give them any rights to develop then, but they have rights to develop when your lease expires. So if your lease is still in effect, then what the people who might want your acreage might do is say, hey, lessor, just give me a top lease and it won't affect your current lessee. I'll just be there. Well, of course, you have somebody there urging your lessor to find a breach, which is one thing. You have somebody waiting to step in as soon as you slip at all. But the other thing is that a top lease, one reason you would care is the top lease affects your lessor's ability to extend or change the lease. So if you get in a situation where your lessor you might want your lessor to give you an extension of the primary term, or give you additional time to get a well in and get production. If there's a top lease, your lessor may not have that luxury, which is why if you are doing leases now, most leases have an anti-top leasing provision that basically says, if anybody wants a top lease from you, you have to let me top lease instead. I have the chance to meet those terms. And most importantly, our existing lease will be the lease that's effective, not the top lease, which typically has a higher royalty or some other benefits that the base lease didn't have. And we can still change our base lease. And that's a very simple provision that would do that. So with a bunch of new plays coming in and people looking to lease, it might not be a bad idea to dust off your leases, see what's in them, because once they're made, people tend not to look at them. Look at your administrative processes to make sure that there are no slips, because there will be people out there looking to find holes that would let them take your acreage. I know we're a little over, sorry.
We're going to try to stay close to the schedule, but great group of presentations, and we could take some time for a couple of questions if we had some questions from the audience.
They're all asleep.
They're all eating their candy.
Sugar crash.
Yeah.
Economics play into a reason for not further developing a lease?
Yes, because whether a reasonably prudent operator's economics would play into it. The fact that, I don't have the money or the economics to do it isn't determinative, but it would cost so much, given current market production, or market prices, that a reasonably prudent operator wouldn't do that, then you don't have an obligation.
Any other questions?
I had an acknowledgement. I wanted to acknowledge just the association and everyone here because of the amicus briefs that were filed. I have no doubt that those amicus briefs weighed very heavily in our favor in some instances.